my fellow Americans, are we reaping our harvest of greed? Have we built our house on sinking sand? Why are we being ugly Americans?
Holmes, founder of Homeowners for Justice, your host today for Weekdays Live. And we've got some interesting news, of course, and a fascinating discussion. I tell you, I get information from people all over the country, and I do appreciate that very much. But this is an interesting discussion. I've made no bones about it. The point is that the assignments are not required to foreclose. This is a major issue because we've been saying over and over it's all about the assignments. So if it's not about the assignments, what are we going to do? How can we review this, make sure that this is what is actually the way law is working in California? So we're going to be discussing that. But before we get into that, I want to talk to you about, of course, the news today, which perhaps you know about, maybe you don't, and that is SEC has a new head, and former New York City prosecutor Mary Jo White has been confirmed to head the SEC. Now, we just talked yesterday, and you can look at the links of yesterday's show about all the penalties that the SEC has hit banks with, but also, as we've objected, as others are objecting, there's no criminal admittance. They never admit they did anything wrong. They never admit that. So they basically use the corporations to pay off these fines and fees, and it's just a cheat tax. It's a fraud tax. And this is one of the problems, and we're hoping maybe Mary Jo will understand and maybe step up for the people. It's really hard to say. I do have another article here in Forbes magazine. Mary Jo White, is she a good cop or a bad cop for Wall Street? She's definitely taken on gangsters, and she's taken on all kinds of violators, legal violators. However, as we look down here, item number 4 on this particular article, I've highlighted it so that we can read it to make sure that you maybe look at this article a little closer. Lots of other Wall Street connections. That's Mary Jo. She has a lot of connections. She served as the board of directors for NASDAQ Stock Exchange. In her current job as a partner at Debevoise and Plimpton, she defended former Bank of America CEO Ken Lewis on charges of civil security fraud. So, you know, it remains to be seen. The fact is, I'm wondering, well, as we've seen, it's a revolving door. So whoever is in the agencies is already rubbing shoulders at the minimum and representing and working with the bankers themselves. And so I don't know how much this is going to, help the people. We can only keep pushing and prodding. And maybe if she's not looking to her future career in the banking industry or as an attorney after her stint at the SEC is over, she may be more inclined to have a hammer. And that, because we obviously know that is one of the major things that people look at when they go into the politics. It's all about future careers. In fact, I'm going to touch on that a little bit more tomorrow. I've got some really interesting videos that I haven't shared yet, but I think we'll be sharing them, tomorrow, Thursday, later this week, because this is really the key, one of the major keys to our problem. It's not something that we can unlock this minute, but it is something as we become aware of, we can share with people and over time make a change. It is important that we do make changes. So anyway, we don't know if she's a good cop or bad cop. Time will tell. However, moving on to banksters, gangsters, JP Morgan, of course, is leading the way in cutting jobs. Ain't it great? Aren't you tickled like I am? They've ruined our lives taken our income. We've lost all our homes and property. They get bonuses, and now they're going to cut jobs to make more money. I just can hardly bear it. Right down here, right under this picture, banks are under pressure to keep profit climbing amid weak revenue growth. And of course, employees are among the biggest expenses. So let's just knock them off. Let's not have any employees. And as you've probably started to see, as I see, what do banks need employees for? They're just gambling houses. They're casino houses. They go to the Fed. They make the money. They create it out of nothing. So why do they have employees in the first place? They're not making loans. We know that's true because the fact is it's really out of whack. So now, sorry guys, banks are cutting their employees too. Everybody's going to be on the street. You mark my words. Now, you take this backdrop. Banks are cutting jobs. Job growth is weak. You had a bad report about that yesterday. I didn't even really want to talk about it because you and I both know that most of the job numbers are manipulated. They're making that stuff up anyway. They're chopping off facts. We only look, let's look at this much. Let's look at this much. Oh, let's look at this much. Let's keep shrinking what we look at so that we can manipulate it and make it look good. And if the people don't notice, it's like shrinking the box sizes in the store. And I'm sure you've noticed that. I've noticed that. Same price, smaller box. This is exactly what they're doing. So here's what's classic. I came across this fact. I just have to share it with you because this is about the housing issues. I've been talking about, and maybe you've heard me say before, that the supply and demand is like a game of musical chairs. The chairs are the houses, and the people running around the chairs, those are the buyers. And in a normal market, which most of our country is, we're just normal markets where people run around in the community and change homes. We get moving back and forth amongst the states, but most of the time, the people that are buying and selling homes are just moving to a nicer home, a different neighborhood, bigger family, that kind of thing, or retiring. And what I've been talking about, what's been happening, in my opinion, what I've been seeing is that over the years, as the foreclosures, they'd foreclose these thousands and hundreds of thousands, millions of homes. But if they listed them, the prices would just be, they would really be far lower than they were even at the last bottom in 2012. And I don't believe it's the last one coming. That's just me. So I've been talking about it, a game of musical chairs. They pull the chairs out over here. And of course, all the buyers are pulled out because most of those buyers used to be sellers, except when they lost their home to foreclosure or short sale, they can't buy. So you've got buyers over here as renters or under the bridge. And then you've got chairs over here as homes. And they've been shrinking the game. So listen to this fact. The number of existing homes for sale in the U.S. has been cut in half over the last 6 years. There were 3.8 million homes for sale in February 2007. 3.8 million. And at the end of this February 2013, there were 1.94 million. And that's according to the National Association of Realtors. This is nationwide. They've chopped the game. They have millions of homes sitting vacant. We already know this from other facts. I remind you again, the news article that pointed out they had 1,000 vacant homes just in Vallejo. So they pull all these homes out of the market. They sit there. They pay people squat to run around and mow the lawns. They won't list them. They're manipulating the game. It's a new pump and dump scheme, I swear. And they're pushing the prices up. They're pumping. What I'm worried about is the dumping. When is this gonna come to a halt? Is it gonna be the banks or some other thing that happens? And here's another systemic change. This is a shift in housing that is coming down the road. I see signs of it locally. You've probably seen signs, and as soon as we talk about it, you're going to go, Oh, well, that makes total sense. And this is called one of the biggest challenges of housing in the future is $1 trillion student debt. Now, these are kids that have gone to college, I call them kids, and they graduate. We already know that something like half or more go back home because they can't get a job, they can't buy a house, they don't qualify, they have debt up to, here over their heads. And so are they going to buy a home? Who's going to buy these homes once hedge funds and cash stops buying? And that's a big question. I ask myself that a lot of the time. I'm trying to figure this stuff out as we go, just like you. So listen to the student debt here.
At record lows, but affording a home is getting tougher and tougher, especially for first-time buyers. Diana Olick is looking at housing's trillion-dollar headache. Diana.
Well, that's right, Tyler. Affording a home is getting harder because more Americans than ever are saddled with student loans, and it's showing up especially among first-time homebuyers who are lagging in the housing recovery. Now, total student loan balances nearly tripled between 2004 and 2012 to a debt burden of about $1 trillion, according to a new survey from the New York Fed. In fact, student debt in the U.S. is now second only to mortgage debt, and in turn has a direct effect on getting a mortgage.
If you look at the average student loan balance, it's about $35,000 per person or per student. So if you take a family of two, that's $60,000 to $70,000. I mean, in certain markets, that's almost a mortgage payment. That's almost as much as a house would cost. If you look at the median income and median price of $200,000, I mean, you're talking half of the house.
And that directly hits first-time homebuyers like Sophia Chali, who has $60,000 of student loan debt from graduate and undergraduate schools. She had to move back in with her parents and stay there far longer than she expected, and her debt is now affecting the home she is finally buying.
Without the student loan debt, a year and a half to 2 years earlier would have been the time in which I could have afforded a house 2 years ago, and probably something a little bit bigger.
Now, adding to that burden is the fact that 1/3 of borrowers on their student loans are delinquent, and that's going to keep them out of the mortgage market for many years to come. We've got plenty more online, realtycheck.cnbc.com. Simon?
You know, it is a huge dynamic. Some people are talking about a lost generation. On the one hand, they've got the debt from college, 100, 200,000 if you studied from the bar. On the other, there just aren't the jobs for those young people, as we saw in the employment report on Friday, Diana.
That's right, and it's just getting harder for them as they build up these debts to be able to think about even putting money down on yet another debt, which is supposed to be the largest of their lives, being a mortgage.
Okay, Diana Olick in Washington for the moment. Thank you very much.
And so, of course, now we have the generation that's supposed to be the first-time home buyers so burdened with other debt they can't buy. The loan rules are changing, so it's very difficult. You have to have high credit scores. You have to have proof of funds. It's more, the house has to qualify for the loan. So you have this influx of cash from foreigners and local folks with cash buying homes, keeping the people, the kids, our future out of homes, and we don't have jobs for them either. So this is really a sort of a trifecta of storm clouds that you and I, our efforts in trying to keep people in their homes, keep the economy moving, reduce the stress, because as people are able to be assured that they keep the house, then they will actually spend more money. It's not like these people are basically broke. It's like the banks have been lying and cheating to them and stealing the houses. So we have to stop that. And today I wanted to welcome to the show, you know, I interact with folks a lot about a lot of different issues, and this was brought to my attention. Hi, this is CJ. You're on the air.
CJ, how are you doing?
Oh, fine. Thank you for joining us today. I've been talking about some fairly unpleasant things as you possibly see with the blast on the email and the outline of today's agenda, where banks are now cutting jobs and the housing market faces pretty significant challenges. And then along comes you, and you sent me, I think yesterday or 2 days ago, this article about the facts that assignments are not required to foreclose in California. So tell us a little bit about yourself, what you've been doing, why you sent me this article, and then we can talk about it.
Okay, well, I'll try to keep my dialogue as concise as possible, and I have to say ahead of time, of course, I'm not a lawyer. I'm going to be talking about legal things, but I'm mostly talking about my own experience, and some of the people that you've had on this show are just amazing. I would certainly love to have a think tank with them at some point. But just to give you an idea of what I've been doing, of course, family members, especially older family members, got into the real estate game, as I did back in right around 2000, between 2003 and 2006, I think. And as a result, of course, the older members, took pension money, any money that they could to invest in real estate because they thought, hey, it's an opportunity to get ahead. And of course, found themselves on the opposite end of the tracks as properties started to go down and all the economic problems happened in 2008. And so I pretty much just started to take central control over all of these properties at the time, and as a result, I've had quite a lot of legal experience with civil, federal, limited civil, unlimited civil, that sort of thing.
And were you able to get some satisfaction for some of these family members?
Well, so far, what I have been able to do is postpone things. But there were times when it really appeared like we all might have, some good cases. But California came down with some, serious court cases that favored MERS.
Right.
Two of the big ones are Gomez versus Countrywide, and I believe Ferguson versus Avelo. And essentially those two particular rulings basically say that MERS has standing pretty much to do whatever they want, whether they're assigning, even though we've talked about the issue of assignments, which is another issue entirely, but that essentially MERS can do pretty much whatever they want in as far as the courts are concerned. Now, these issues of Gomez versus Countrywide, Ferguson, have not necessarily always ruled the show. There have been a few bankruptcies in which the actual judges ruled contrary to those particular positions, essentially saying that California law, or I guess precedent in the Supreme Court, has actually, how should I say, gone against the rulings of Gomez versus Countrywide. Of course, those are appellate rulings, from my understanding, and not Supreme Court rulings, but they seem to be ruling the day. And so as a result, it was very, very difficult to maintain some of the cases that we had going on. I had an attorney who I feel free to mention. His name is Mark Turbeek, and he charges a good amount of money, but he really, really knows his stuff. And he was one of the few people that I had ever met or talked to that actually won a unlawful detainer case, where the basic case that he used was unlawful foreclosure, which is almost virtually impossible, but it is done from time to time. Go ahead. I wanted to get a word in edgewise.
No, that's okay. No, we're enjoying what you're saying and learning by it. So what you just said brought up a question to me, because if MERS ruling that if California, which a lot of states and courts have ruled that MERS does have the right to do whatever they want, so does that mean that at least some of the cases you were involved in with your family members were using MERS in some way. You were fighting the either the MERS assignments or substitution of trustees, or what? How were you using MERS, or why did that set you guys back?
Well, I can think of a couple of cases, especially in the unlawful detainer case. For instance, a property that I was finally ultimately went back to the bank, or I finally had to acquiesce. But this property was foreclosed back in 2009, and I still maintained and kept the property for about almost 3 years. It might have been a little over 3 years, actually. And what was fascinating about this, there were several circumstances, but I don't think this is uncommon. I happened to actually have a family member that owned another property out of at least out of the area where I am now, and the people that actually served the unlawful detainer papers, the 3-day notice, I guess they call it 3-day, 60-day, 90-day notice to quit. Jackson and Associates are their name, and they do a lot of serving in unlawful detainer proceedings. And one of the things that they did, which I believe is common in both of these instances, is they actually did not serve, mail, or post this 3-day, 60-day, 90-day notice on the door, mail it to the property or anything. They claimed that they did, and of course they had a person that signed an affidavit claiming that these were posted, but they actually weren't, and seriously they weren't. I mean, sometimes I shouldn't say advise, but I might say you can always use that as a defense, that it never was actually given to you or posted on the door, but generally the court won't believe it. And in this case, a lawyer that we had actually was able to convince the judge that was a particular issue that could be put in a trial as to whether they did post the actual notice. And then another issue came about that the judge in this unlawful detainer case was also willing to accept the validity of MERS as far as its claimed ability to assign the note and the deed of trust, and of course any other paperwork that they had had anything to do with the judge was actually willing to allow those in the particular unlawful detainer case. Unfortunately, I decided that, or I think the company, I think it was IndyMac Bank, they decided that they were going to dismiss their claim, which, by the way, was actually the second unlawful detainer claim. The first claim, they dismissed it because of, I'm not sure why. Then the second one, when the judge ruled against them in their motion for summary judgment, and based his rulings on, surprisingly, a rather lengthy, how should I say, a decision to allow us to have certain issues in the actual trial. But of course, they dropped their case. In retrospect, it probably would have been best that we continued the case and not allowed them to drop the case. But at the time, I was fighting so many other battles, I decided to just let sleeping dogs lie. Unfortunately, the third unlawful detainer case that they came back with, they ultimately won because the judge was no longer in that particular court. He had been moved to a different courthouse, or I guess responsible for different things. I like to think that the banksters were arranged that, but not necessarily. The point being, though, with regard to MERS, it was not too long after this case that Ferguson, Avelo, and the Gomez decision versus Countrywide came down. And after that, it was, I was told by my attorney at the time, and for, through just, I tend to go to court trials and hearings, especially where bankruptcy is concerned. And I started to see that these issues were readily accepted by the judges, these decisions rather, and then it kind of upset the ability to use the traditional MERS, assignment of mortgage note, that sort of thing, or I should say assignment of deed of trust and note.
Right. right, as a defense, as a way to fight the foreclosure. Now, you keep saying UD, so to me, unlawful, that's an unlawful detainer, and that means that takes place after the house has been foreclosed, right?
Correct. And now, thank God, only about 3 of the properties that I've handled for myself and family members have actually gone into been foreclosed on. There have been 3 that have been foreclosed on that I managed to get those foreclosures rescinded, and that was somewhat of a challenge. And that hasn't always worked, but every once in a while that does work. Do you want to talk about that at all?
Well, absolutely. And then let's be sure that let's talk about these assignments first. And you're already saying, which I've been picking up around the country, in general, most courts, not bankruptcy court, but state and federal courts are saying that MERS is okay, that they do have the right to make assignments. And now what you sent to me, let's be sure we talk about that, and then I want to hear about how you got some foreclosures rescinded, because again, just the sharing of these experiences, successes, failures, whatever's working, not working, that we're sort of having a little mini think tank almost every day on this topic. So you sent me this article on the fact that assignments is not a prerequisite to foreclosure. So I wish
that wasn't the case, but for the most part it is. Now, judges are all a little different on this issue, and there is a Supreme Court case which is actually mentioned, I believe, in that particular article, that claims that assignments for deeds of trust and assignments for mortgages are one and the same, since both are security instruments. But the latest cases, and especially one I don't think I mentioned to you, I was going to find that information. Every once in a while I remember it. It's something versus HSBC. Let me find that case here just to tell any of the listeners.
Is that
Calvo versus
yeah.
HSBC.
Yeah.
And that was an appellate case where basically they're saying that any sort of a security instrument like a deed of trust cannot, or an assignment is not necessary, because as long as the trustee is substituted for the proper trustee, they can continue to foreclose. And that is one of the issues. But remember, that's an appellate case. And probably it's difficult to say which courts will absolutely rule based on that appellate case, as opposed to the Supreme Court case, which is quite a few years ago, which raises a bunch of other questions when a case is like 75 years old. Sometimes
exactly.
It's difficult to use that in court of law, because they'll always say, well, business practices are much different now than they were then, that sort of issue.
Now, see, this article that you sent, I've got it up on the screen right now. It just says that this decision, Calvo v. HSBC Bank, reinforces the rule that California does not require recordation of an assignment of a deed of trust prior to foreclosure, and that the civil code, these are one of our foreclosure codes that we're pretty familiar with, 2932.5, is inapplicable to deeds of trust. The ruling clarifies that the statute does not apply when the power of sale is conferred in a deed of trust rather than in a mortgage. But like you've said, these are both security instruments. And so now this article being written is stating that this ruling will serve as a recent precedent for California courts to strike down the thousands of foreclosure lawsuits that allege a foreclosure is invalid when done in the name of MERS without an assignment.
And they will do that. Now, that doesn't mean that if anybody is actually filing a set of causes of action, in a quiet title action, or any sort of action against the banks, you wouldn't question the issue of assignment, because you never know how a court may rule on that. And let me also state that there was a point where Countrywide, or I should say Bank of America, stopped all foreclosures supposedly for, I don't know, maybe 3 to 6 months time period because they were going to so-called fix the problems with the so-called recorded instruments. And we all know, of course, they just made them up as they went along. But
Right.
one of the things that they did do was to make sure everything was theoretically properly assigned. So let's put it this way: if you go to court and there are no assignments, but it's in California, and the substitution of trustees are done in the prescribed way, meaning that theoretically, if you get a notice of default, and of course it has really different trustee than you ever see, and then 3 months later you see a substitution of trustee that then substitutes the trustee that's mentioned in the notice of default. Then, theoretically, and then as long as they then have the notice of sale and then the trustee's deed upon, if they do that all in order, generally it'll work. However, there are substantial case laws, a few of them, and I can certainly get them for you. I know I have them somewhere, that show that if a substitution of trustee is done after the trustee's deed upon sale, that won't fly with the courts.
Right, correct. And what's really frustrating is that virtually anybody can send out a notice of default, and then they can fix that with a trustee substitution, fake one of those, to get the right name into the person that sent, the entity that sent the notice of default. And as long as it's done before they've actually sold it and put the trustee's deed on sale on record, that it's legal. And so this is very troubling to people. It does feel like a
That's
theft.
the question whether it's legal or not.
Yeah.
Don't think it really should be legal, but I can find no case laws that state a necessity for chronology within the whole deed of trust process from notice of default on to trustee's deed upon sale. There's no question that how could one party issue a notice of default if they hadn't been given title or if that trustee had not been given that information yet. I mean, it seems so obvious, but most judges, for some reason, just don't even listen to that and don't know what to say about that, unfortunately.
Right. It is very troubling because it does feel like anybody could just send out a notice of default and take the house, and then, it's like, whoops, fix the whoops later. I wanted to read this on this page on this article. The fact is that California case law does not require recordation of an assignment prior to foreclosure of the beneficial interest under the deed of trust is unnecessary because it's the trustee, not the lender, who holds title and transfers that title upon sale. Therefore, so long as a substitution of trustee, if applicable, and applicable would mean the trustee on the loan is not the same trustee that's going to be foreclosing. So then they would need a substitution of trustee to substitute a new trustee in for the one that was on the note. So if it's applicable, then that is recorded prior to the trustee's sale. So it doesn't matter if it's recorded.
This article is the opinion of the person who's writing it. It's not necessarily fact.
That's
but
right.
It does reflect the essence of those specific cases that they're talking about. Yes.
That's right. And then they're citing the cases, and I will load this up under legal action by state, this opinion under California, after the show. And so, and here again, now, see, you've talked about, I've mentioned, there's a conflict between the bankruptcy court's interpretation and the California State and District Court's interpretation.
Yes.
And so, because if a person actually goes to HOFJ.org and looks at legal action by state, it's just a web page, and goes down to California, or just look down the whole list all across the country, and you see cases that are against MERS in favor of the owners, it's basically bankruptcy courts. Those are the courts that I think seem to really understand chain of title and take it seriously.
But you need a good attorney. You need a very good attorney, and I can tell you that just to give you an example, I've helped, I won't go into greater detail about this, but I helped an individual in a bankruptcy file a motion in opposition to relief of stay. And just to clarify, relief of stay, what happens whenever you file a bankruptcy and you list any property within that bankruptcy, then of course the bank that owns the property will file for a motion for relief of stay so that that specific property can be taken off of your bankruptcy estate so they can be free to foreclose.
Right.
So there was one instance where I wrote an opposition, and I believe it was a pretty good opposition. I used templates from similar oppositions, but tailored it to the specific instance. And this was a very unusual situation, and it was an accident, but the particular client, or I shouldn't say client, the friend that I was helping, had filed a bankruptcy case, but it accidentally was dismissed because a certain one paper, I think, I think it was Schedule F or something like that. It accidentally was dismissed. And then in the process, I talked to him, and we decided to work on trying to get it reinstated. But essentially, it took the judge a long time to even act on the potential of reinstating it. So in the process, my friend filed another bankruptcy case. With the same issues, same property, of course. And before both judges, two separate judges, this, by the way, was in the Eastern District in California. And it was so funny because the same issues were in the same relief of stay, because it was basically the same relief of stay. And one judge on the newest bankruptcy case that had been filed because the other one had been dismissed, he ruled in favor of the bank, granting their relief of stay. But it just so happened, prior to that ruling, the other judge had actually granted my friend's motion to reinstate the first bankruptcy case. Then another judge, a totally separate judge, ruled in favor of my friend and against the bank for the relief of stay. And it was the same exact thing. Both judges had the same information, but both ruled separate, ruled totally, opposite. So there were certain issues in there. One issue was that this particular property had been already foreclosed, and because of that, the judge said, well, if it's already been foreclosed, one of them said there is a colorable title held by the person who foreclosed, or the beneficiary named in the foreclosure. But the other judge said that the other side did not provide the proper documentation. None of what they provided the court had any certification whatsoever, and were inadmissible. I mean, the judge just pounded who ruled, at least in my friend's favor, pounded on the other side. But then ultimately what happened is, once the case, the first bankruptcy, which was ultimately allowed, we ended up, my friend ended up actually dismissing his claim in the second bankruptcy. But once it discharged, then of course the bank went right ahead and continued to the unlawful detainer process, and ultimately got that property, which is another story unto itself, because I tend to believe that once a property has not been granted how should I say, the relief of stay has not been granted to the bank, I believe that remains in the estate of the person who filed bankruptcy and cannot be foreclosed on until the bank actually gets a relief of stay. But unfortunately, the unlawful detainer judge disagreed, and my friend was considering the possibility. I even said I would try to help of trying to open up this bankruptcy case to actually settle the issue. Theoretically, he still could, but
yes,
it's a lot of work.
Absolutely. And I thought that was very fascinating, that you've got virtually the same case in front of two different judges and two different rulings. And this is part of the problem that the people face, even if you have, if you will, a perfect presentation, that's not necessarily any guarantee. That's a real troubling thing. Now, I wanted to bring this up too. I've pulled up more of the California Code because the Homeowner Bill of Rights changed the law, some of these foreclosure statutes in our code. And this particular one is where we talk about that all of these, you know, a notice of default, notice of sale, assignment. Now they're talking about the assignment, so you can do an assignment, or a substitution of trustee recorded on or behalf by a mortgage servicer in connection with the foreclosure, blah, 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 shall be accurate and complete and supported by competent and reliable evidence. Before recording or filing any of the documents described in that subdivision A up there, a mortgage servicer shall ensure that it has reviewed competent and reliable evidence to substantiate the borrower's default and the right to foreclose, including the borrower's loan status and loan information. Now, I believe we ought to be hammering on that because, and like I've heard other attorneys say, just because it says so on a piece of paper doesn't make it so. You have to look for the proof of that. So if
Absolutely.
So I think what would be really helpful, because here I am right in the middle of doing these shows and talking to these people and hearing all this stuff, and I cannot sit right now and just itemize out off the top of my head, okay, what constitutes proof? What should the people be demanding? Tell me what the proof is. What's the proof that they have, that the information they have is accurate? How do we make them prove that in a court of law? What does it mean by having that information being complete and then supported by competent and reliable evidence? What exactly does that mean? And what should we be going after, even in our qualified written requests or debt validation letters, which is something, you know, people can do without hiring an attorney, as long as they relatively understand that and have a template to follow. And then, of course, as we get this information, how could that be used in a court of law to help people keep their homes? What's your comments on that?
That's where the think tank has to come in. I mean, you've had some amazing guests that I'll tell you right now, I am totally humbled by your show. I mean, I thought I knew enough. I mean, I knew enough to be just enough to be dangerous, perhaps.
That's how I feel.
I know that, you know, my biggest philosophy has been just postpone, postpone, postpone. You just don't know what's going to happen in the next 3 to 6 months. I mean,
right.
You were, for instance, I mean, and I don't want to get too far off point here, but I was just reading yesterday about Blackstone, I guess a company that's bought a tremendous amount of properties for rent.
Yeah.
And I remember reading other articles, and I think you had read the same article, where it said that only 52% of the properties they have are actually rented now.
That's right.
This may not be Blackstone, it may have been another company,
yeah.
But
pick one. Yeah.
I just went through some of the information that they had, and they talked about a house that they bought at a trustee sale for $150,000, and it's probably theoretically worth $300 and something thousand. And I just did a little cursory information, you know, just to kind of go. I figured that you got a $150,000 loan and this, of course, their particular property is a non-owner occupied property.
Right.
And of course, they're getting people to loan them the money, not banks, I'm assuming investors.
Right.
But even investors, they've got to give them some sort of a return. And I'm assuming if that return for investors is, well, let's say the total percentage that somehow they got is, let's say it's 3.25, which if it was through a bank, it would have to be probably 4 or something if it was a non-owner occupied property. But just the principal and interest on that is going to be $652 a month.
Right.
Not including taxes and insurance, which is probably going to make the total over $1,000 a month. And then they're going to rent the place for $1,295. So they're going to have a potential profit of $295, maybe right around there per month, except that they've got to fix the place up too. And
right.
They've only got 52% of them rented.
Right.
I do not, in my possible wildest dreams, cannot fathom how that could be a money-making opportunity. I mean, I can tell you personally, and I don't want to get too personally, but through just the consortium of family members that we've been trying to rent properties, and these, of course, are properties that are still technically in foreclosure that have not been foreclosed because we have to do something, and of course, especially if they're trying to get a loan modification, tier 2 MHA and of course the Department of Justice in California allow you to rent the properties and but you have to claim it. Now, renting them, when you have to tell the tenants that there's a potential foreclosure, that's not an easy task.
Right.
But even with renting it and not paying mortgage, and not paying property taxes, almost impossible even under that situation to make much money on it.
I know where you're going. I know, because we're an investor. We have rental properties. And the fact is, and this is why I say things like I do, the hedge funds are used to doing, stocks and bonds. And they do all this paper analysis, and they analyze it, they put it in their formulas, mathematical, whatever, and they decide they're going to invest in this company. And then, of course, something doesn't work out or something changes, and bam, they sell. They can do this literally at the blink of an eye all year long. But rental property is very slow moving, and it's tenants, toilets, and trash. And so no matter how good the numbers look, what actually happens is they end up having to deal with property managers and people and renters that move out and damage the house and leave a pile of trash and didn't pay. And by the time they got them out, they have, another $10,000, $15,000 worth of repairs. And I'm telling you, I know how they make money. I swear. Blackstone makes money on other people's money. And so they've sold all those investors a bill of goods, in my opinion.
Oh, yeah.
And they have told those guys that what they have done is they have factored in, not the income stream. In fact, I was suspecting that some of them would actually say, we won't even get involved with people. Are you kidding me? We'll just keep them all vacant. And we'll board them up and we'll mow the lawns. And then as the market pushes the prices up, we will sell. And you will be on that, that appreciation hump. And so they will factor their guesses as to what that hump looks like into the returns. And so many, many investors do not need or want monthly payments off their income, off their investment. Quarterly is okay. They really prefer annual. Or I got an idea, let's just let it accrue. And that's what most of these large investors do. They don't need the income, so they let it accrue and accrue. And so what that means is a company like Blackstone, the hedge funds, they don't have any money going out. It's all book paper. It's all paper. It's all, little sheets sent to each of their investors on how much they made this last quarter, whether they did it or not. So it really, in my opinion, probably at some point will blow up. That just seems a natural, logical thing to me. Because if you don't have to balance the books or show exactly or cut, accept your losses immediately, if you can push them off and say, well, we're not even going to call those losses because we're going to make such future gains that offsets that, whatever excuse will do. And that's what I think is happening. Now, it may be that their funds are set up differently. And if they are, and the investors do start to recognize that they are not getting the return they were promised, then they're going to want out. They're going to be what we call in real estate don't wanters.
Will probably figure out some way to sell all these properties to another firm. A murderous acquisition. Anyway.
Exactly. Exactly. And they will have scraped the fees off year after year after year. And it's always the investors that are at risk.
But I just have to state, and I believe, this is just a personal belief, I'm going with the fractional reserve number of 10%. I don't know why I picked that out of thin air, but I believe that only maybe 10% of the actual houses that could be on the market are on the market. Maybe less. And I'll tell you why I believe this is because I've noticed, I've looked at the Recon Trust website. I mean, that's my source. And as of yesterday, they had, at least in the Sacramento area, they had 120 houses on schedule to be foreclosed or through trustee sale within approximately 2.5 month period.
Right.
I can tell you last year at this time, it was almost 2,000.
Right. Oh, there's been a huge drop.
All of those homes have been foreclosed and sold now. I don't believe that. I believe they've just taken them off the market to try to raise the price artificially.
Correct. And I believe that, for one thing, what the I subscribe to Foreclosure Radar, and will see actual foreclosures and all those that are pending. And the pendings are down. I remember I did for KPFA, oh golly, about a year ago, and we were looking at about 120,000 families facing auction in the next 2.5 months. And now when you do that, this is California, statewide. And now when I just ran that number again a couple weeks ago, and it was down to about 59,000. So there's been a drop in the folks facing foreclosure, but that doesn't necessarily mean they're out of hot water. It means that either they're going to short sale or they're doing some kind of bankruptcy litigation. Everybody is still fighting. And in the end, we'll probably get some kind of a deed in lieu. I'm not even sure it'll go to the steps or ever be turned active, bank-owned property. I believe that as we go, more and more of, our records are not trustworthy.
I consider it a stay of execution if they're not foreclosing right now. I think that they're playing a little bluff game with the people. That if there are actually potentially 3,000 or 4,000 per month for the next year that could be foreclosed, but the bank's only selling 150 within a prescribed period of time, I believe it is a bluff game. They're playing a game saying, oh yeah, we will foreclose unless you do a deed in lieu, or recently they're offering you the opportunity to do a deed in lieu and then rent your own place for far more than even market value, which is so nice of them.
Right. Well, and I've been saying now,
I would highly suggest that people just hang on to their properties as long as they can. Now, again, I realize that there is a very good chance, especially if it was an owner-occupied, they may get you on some sort of a judgment later on, ask for money. I guess that's the perfect time to file bankruptcy.
Right. And I've been saying for actually several years that I have watched, because I've counted the numbers. How many did they foreclose? How many did they list? How many that sold in the MLS, because I could count this in the MLS, were actually bank owned? How many were short? And I've been doing the numbers and the percentages. And definitely in the Bay Area in particular, our 9 counties here, the if X is what they listed, banks listed in 2011. In 2012, they listed half X, 50% of X. And so far this year, they're listing 25% of X. It's just been slash. There's virtually no bank listings as far as the market goes, particularly if you get above the median price, whatever that median price might be.
Remember, they weren't necessarily listing all of the properties available then either.
Absolutely. And so I've always said they have this big reservoir. I see they have a dam, and this reservoir just goes on forever. All this water, all these homes, vacant homes sitting there. I mean, millions of vacant homes sitting there, and that they are going to empty the reservoir with a garden hose. Just a little bit at a time. And now I think they've really, I swear, that they are manipulating this to get median prices climbing as high as possible before they sucker all of these vacant foreclosures into some hedge fund, at higher dollars.
For you. That's capitalism.
Yeah, and they're the insider. They have all the inventory. They have, in fact, 2 days ago was that banks now own 50% of the equity, housing equity in this country, more than Americans. And that these are just astonishingly scary numbers, because it really does feed into what I've been feeling. You know, my intuition is they're turning us into a renter nation. They are the land barons, and they are getting off. We're not even sure if Mary Jo White at the SEC is going to hold any of these people's personal feet to the fire.
No, she's not.
No, probably not. She's already in the cartel. Are you kidding?
It's about unfair, business practices. I mean, honestly, I could go on a rant, and I actually want to come up with an idea, but just let me rant just for a little bit.
Okay.
About the great scheme that they have through the Federal Reserve.
Yes.
And Goldman Sachs.
Yes.
And first of all, everybody who's ever worked for the Federal Reserve has worked for Goldman Sachs. So, of course, any information that the Federal Reserve knows, Goldman Sachs knows.
That's right.
Of course they buy and sell securities based on that knowledge. Is that insider information? Well, of course it is, but it's not really. You can't prove it.
It's legal.
Recently, I guess it was SAC Investments or something, I read that in the paper, how they're paying a huge fee to somebody for insider trading, supposed insider trading, which probably is. And I really, really believe it was Goldman Sachs that probably pushed that investigation.
Right.
Because this is the way the country's been working, and insider information is really the only surefire way to make money in the stock market and everything. And certainly that's the way it works. But that's my rant. I don't think there's anything we can do to stop that. One of the things that I wanted to talk about, have you ever heard of the Ibanez case in Massachusetts?
Yes. It's a key court case. I'll pull it up.
And I'm not sure exactly how that can help us in California, at least totally sure. But some of the issues that they really went into dealt with the pooling and servicing agreement and talked about the mortgage loan schedule. And they had a specific standard within at least, I call it the Ibanez standard, that stated that, well, normally if you are able to find a mortgage loan schedule, which is probably maybe on a third of all mortgages, or I should say deeds of trust or whatever sales that have been put out there, generally the only way to identify the specific mortgage is by I say mortgage homogenously, is by the zip code, the sale date, and the amount of sale. And that's pretty much all you're going to see on most mortgage loan schedules, if you'll see a loan schedule at all. I believe that any bank that claims to, I should say any entity that claims to own your property that you're going up against in court, I really believe that still, in spite of all the things we've discussed, I still believe that they have to prove at some point, through some clever manipulation on our part, to get them to prove that they actually, or that note was actually put within their particular mortgage pool. And they'll do all sorts of tricks to say, well, it really doesn't matter, we're just a trustee. Let's say U.S. Bank is a trustee. We'll just say we're suing as trustee, and we're the trustee for 1,000 pooling agreements, so we'll just sue on that basis. And if you don't get them in the right way, come underhanded out of left field in the right way, they'll probably get away with that with the court. They do all the time. But if you're able to pinpoint the specific pooling agreement they claim owns the property, like I say, probably 2/3 of those pooling agreements, if you look on them, they will say mortgage loan schedule intentionally omitted. Intentionally omitted. So if you find that, then really the only thing that they could possibly give you to prove that they hold the note or hold some sort of interest in that property would be their own mortgage loan schedule. But all I can say is in court, how can they prove that that's authentic?
Well,
just print it up.
See, and this is exactly what I was sort of implying or intimating or asking about, and that is the competent complete, competent, and reliable evidence. And so there's got to be a way. You know, Joe comes on and he parses these words. It's so fabulous. So come on, Joe, parse these words for us. Tell us what each of these mean.
Get him on more. I love listening to that guy.
Yes, yes, because I swear there's a key here, and you know, and it says reliable evidence to substantiate the borrower's default and the right to foreclose, including the borrower's loan status and loan information. And if we could, you know, parse that into what you were talking about here on the Ibanez case, which was a real win, and I've got up on the screen right now the chain of entities through which the Ibanez mortgage allegedly passed before the foreclosure sale. In other words, even if the assignments don't matter, the trustee substitutions do. And if there's a substitution, the entity that actually owns the note, that is the beneficiary of those payments, is the lender. That is the only entity that has the right to substitute the trustee. You can look at the codes. And so if we could fight on the fact that, which is virtually the same, it's who is the actual beneficiary, and how can MERS be that beneficiary or do that trustee substitution when the loan should have gone through all of these people?
And that's the issue that has to be really, really pressed. But to get the court to listen to that, some of your other guests have talked of methods to, for lack of a better word, try or at least attempt to manipulate the court. Manipulate isn't the right word because courts should be doing this all the time.
Right.
But to actually get the court to listen to our particular claim, which is very difficult in propria persona, because if you're representing yourself, the judge is going to give you a smile, saying, you know, okay, I know you just don't want to have to pay. We both know this. And that's always going to be a very, very difficult thing to overcome. But assuming you can overcome that and actually get the court to listen to the evidence, also I want you to consider that I had a loan through IndyMac Bank that I did actually find the loan schedule. And as a matter of fact, I found this exact same loan on 19 different pools, separate pools, different pools, showing the same date, the zip code, the date, and the exact loan amount to the cent.
And it was the entire loan amount?
Yes, it was. Like I say, based on
Right.
the Ibanez standard may have, and I believe they actually said there has to be an address. It's highly dubious that you'll ever see an address in a loan schedule, but I'm saying based on the information that you'll normally see if you do have a loan schedule, just the zip code, the amount, and what else did I say? The amount of the loan, the zip code, and the date.
Date, right.
I found, like I say, 19 different mortgage pools.
Right.
Made at the same time, which means that there's a very, very good chance, solid chance, that investors who invested in these pools paid for the same loan that was sold to each one of them by IndyMac.
Right. They sold the Brooklyn Bridge over and over and over.
They sold it over. That was why they were ultimately probably closed down, at least one of the many reasons. But when you really, really think of the implications of that, it means that investors were really, really taken for a ride. Unfortunately, that's not information we can specifically use as far as the investor complaint is concerned, because we don't have any standing to act on part of the investors.
Right, right.
If it really came down, and I always felt that if I could get the court to consider that there were 19 separate mortgage pools that somehow claimed ownership to that property, they would maybe at least be interested in the potential of saying, okay, well, maybe this person should prove that they are actually the holder in due course, or the something, some sort of beneficial interest. But unfortunately,
Exactly.
It never got to that, because getting the court to even listen to that past the MERS issue is almost impossible unless it is done, the initial case, and causes a transaction are done in a specific way, and that's what we really have to do, CJ.
Right. I agree. But the point is, and it ties back to what I've been asking, what are those proof? What is the proof? Like, see, I've got up on the screen right now, according to Wells Fargo, option 1 later assigned the LaRace mortgage to B of A, flow sale servicing agreement, assigned it to Asset Backed Funding Corp on October 1, 2005. You know, this is going through the Ibanez case and how they had assigned it to Wells as trustee, blah, 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 pursuant to a pooling and servicing agreement. And so they have here itemized what, according to Wells, what they had said, and then they have itemized earlier what we first looked at of what they should have done. And what I want to know is, writing the cases correctly, what proof would be demanded? I mean, there should be some proof of sale, shouldn't there? My understanding is that these are supposed to be actual sales. Money should change hands. So if money doesn't change hands, how can they prove that the next entity in that chain actually owned it? And maybe that's where we can get them.
In theory, one thing that they could do is they could go to the Blomberg terminals maybe and get information on that maybe. But I think you have to realize that there's a very, very good chance the accounting practices are, fraud is part of that model too.
Exactly.
Obviously.
Yeah.
And
yeah.
they will come up with whatever information they can say was a payment stream of something that was paid to so-and-so. They can make it up practically, and
right.
They could maybe even find it something that would be traceable through the Bloomberg terminal. But that wouldn't necessarily be, that may be somebody else's payment stream, but you couldn't prove it.
Right, right. Yeah, and we saw yesterday on the whistleblower for the Independent Foreclosure Review, which I've now uploaded to the homepage on Homeowner for Justice, and that is they manufacture documents on demand. We need the proof of something. There you go. Well, we should have mailed something out. There it is. And this, when fraud is a business model, then no results can be guaranteed. I mean, this is it's going to have to be I think a combo legal political action solution. I mean, the people have to get really irate and understand in at least the simplest form is that the banks have been just cheating.
I want to believe that at some point this consciousness will prevail, but in the meantime, I think that the real thing here is, since almost all of these cases hinge on the same issues,
yeah,
I really, really believe that we have to get some sort of a boilerplate set of causes of action, and it can't just be 10. Really, it's got to be as many potential causes of action. I guess even the RICO statutes, of course, that's the problem. Then you get to federal and state. If we're just sticking with state, you want to try to stick it to them as many as you can, because there's a very good chance the court's going to throw a lot of them out. The issue of all of your notary, making sure the notaries are the correct notaries, the signatures match up, Secretary of State, those are all great. I was ready to, I haven't done that yet, but I've been ready to do all of that. But then I think you mentioned that a lot of times the Secretaries of State are not actually giving the signatures when the notary hasn't renewed. When I heard that, I got to say my job, a little bit of my enthusiasm kind of dropped or waned.
Right. In other words, people have to get right on it, because if they don't renew their commission, then theoretically they're supposed to turn in their logbooks to the county. And theoretically you can get journal entries from the counties. But I'm not sure about signatures if they don't renew the commission and you can't get the signature then from the Secretary of State. I don't know what you do. Other than we try to work together, and everybody that already has signatures, send them to me and I'll upload them, and then we can at least share them.
Right, certainly, and that's a great, of course, then again, all of those different signatures have to figure out the official source to be able to authenticate those, so that the court would actually accept them as evidence, and that's another issue. But certainly we have to try this from find specific statements within it, and I think some of your guests have talked about this, that state when the cutoff date for assignment is for this and that sort of thing, and just get to absolute specifics and then figure out the exact scenario for which the court will actually listen to that information. Then we have something.
Something to work with. Absolutely. And in the meantime, it occurred to me, let's everybody call the Attorney General's office and demand a statewide grand jury, at least in California, and start asking for the grand jury investigations into these fraudulent forged practices. The fact is, every AG knows about robo-signing. That's why they signed the settlement. And so let's insist that the like we know, robo-signing is forgery and false notarization. And you know, the AG might think, they might take a step back because they may not have actually connected that, you know, robo-signing, which sounds dismissive, is really forgery and false notarization combined. And that sounds a lot more illegal and worrisome and troubling, because it is. And let's push, you know, the political push, trying to get the grand juries, trying to get the information out. I'd love the suspicious documents. Jed sent his out. I got to get mine together. Everybody needs to work on that.
Yeah.
Because I'm still working on putting together the 18 properties that I analyzed and sent to the Attorney General for the statewide grand jury to push that. And then, of course, 2 of the 3 people were on vacation or something. I mean, you know, it always takes longer than you think, but we just keep pushing, keep pushing.
I love, you know, if there's a collective consciousness, it's very difficult because we are all so busy in so many aspects of daily life just to keep things going that it's almost impossible to really get together and work together. But I love to share any knowledge I have, but specifically this potential for a think tank. You had a couple of guests. I've kind of formulated an idea based on some of the guests you've had. One of them talked about do the qualified written request and the issue of you know, suspicious documents, to be able to formally suspend the trustee for I forget the charge, or you know, but to be able to do that and then have a court case based on that, and then be able to challenge the suspicious documents on that basis. And then once you do that, and if you're successful, then go to quiet title. And then once you do that, then well, you know, then go to, you know, whatever other potential court cases need to be claimed. Actually, technically, if you win the quiet title, that'd be great. But it seems like there is a specific step-by-step different types of cases that we need to file before we go for the big one.
Right. Right.
Generally, quiet title is on the end of, is one of the causes of action, or one of the requirements that we're asking in our particular complaint, because they did us wrong. You know, they did this, and this, and this. Therefore, we want quiet title. But generally, that's not the best basis for quiet title.
Yes, and I've now had attorneys say, oh, you don't want to do quiet title. So I'm trying to get one of them on the show to, okay, if we don't do that, or explain what we need to be focused on and doing. And I like the think tank. In fact, just the other day, someone used the word summit, and I thought this would be really fabulous if we could actually attract all the interested parties, attorneys, researchers, and get together, bring everything that doesn't work, that you've lost over in court, everything that you might have gotten a win on in some way, shape, or form, and all these ideas, and research. Let's figure out a boilerplate solution. That's really my goal. And I appreciate you sharing so much.
I'm there. If you need to rent a place and everybody pitch in, I'm there.
Okay. I'll have to run a little survey. You want to come? And that'll be great. All right. Thanks so much. We're going to have to call a halt to it today. I really appreciate your input, and very good luck with your family and the effort. I do know that literally everyone feels like they're under pressure, at least in our group. All the people fighting foreclosure, they've lost work, they've lost income, lost jobs, they're fighting the banks, they're being lied to and cheated, and it really is stressful. We thank you so much for hanging in there with all of us. And to lighten the mood, I'd like to end the show again today with Bugger the Bankers, because I swear we're going to end up doing that. Thanks for watching, guys, and thanks for sharing with us today on the show.
Thank you, CJ. Have a beautiful day.
You too.
When I was a lass, I was proud of me class, like my father and mother before me. They taught me to fight for my civil rights, but it's always the same old story. The rich reign supreme while the poor can but dream, under Labour or Liberal or Tory. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules, and if you're one of them, bugger you, and if you're one of them, bugger
The system is bent and the money's all spent. We're measured from every direction. The workers get taxed while the wealthy relax.
with nary a moment's reflection. Where there's brass, there's muck, and they don't give an arse, 'cause they're programmed against insurrection. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules, and if you're one of them, bugger you, and if you're one of them, bugger you. Now all you good people with passion to vent, don't give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent.